Good afternoon, everyone, and thank you for joining the November podcast here for 12 Points. I'm really excited to be hosting today. My name is Christopher Cahill, a partner at 12 Points Wealth Management. I run the Family Office Services Group. And we have our esteemed friend and colleague from Archstone Law, Andrew Butler, here with us today. So we're going to cover the essential legal documents that every family needs. We're going to touch on some real basic information here and a little bit more complex information. And I see that there's more of you rolling through. So we're going to just get going timely here and make sure that we're making effective use of our time. And by all means, should you have any questions throughout the podcast and presentation here, just chat them, throw them in the question box, and we'll do our best to answer them. And I'd like to just start out by saying that Andrew is an attorney licensed to practice in Massachusetts. I see some of you from other states here. A lot of this information is generally applicable, but state-specific information outside of Massachusetts is not going to be something that we're going to be covering today. But again, I think that there's a lot of general applicability that is going to be consistent throughout. So without further ado, let's proceed here. So here's my smiling face, Chris Cahill. As I said, I am an attorney, certified financial planner, and chartered advisor on philanthropy. And, I work primarily with successful business owners now, people that are looking to make a lasting generational impact with their wealth. I'm often sought out by people like Andrew and CPAs and other business advisors to help their clients who are focused on passing on more than just their wealth. They're really looking to pass on their values and make a difference in the world. So enough about me. Let's get to our guest speaker here today. So Andrew Butler, Archstone Law. Andrew, why don't you tell us a little bit about yourself and your background?
Great. Thanks, Chris. Really great to be here today, and glad to see we've got so many people joining us. As Chris mentioned, I'm Andrew Butler. I'm a principal with Archstone Law Group. It's a small law firm based in Newton, Massachusetts. I've been focused on this type of work, estate planning, estate and trust administration, for actually over 30 years now, despite what the slide says there. And I work with individuals, families, and addressing all of their estate planning and related needs. And those other needs always involve working with other advisors, including folks like Chris. So, and just wanted to use today to give people at a pretty high level, sense of what estate planning is all about, talk a little bit about some new developments with the Massachusetts estate tax, and touch on a couple of other related topics. And we'll mention this again at the end, but obviously if there are follow-up questions, you'll have my contact information, Chris's, and feel free to reach out to us. And actually, I should just point out, technically it's Archstone Law Group PC. Don't want to give a false impression that we're an LLC, but
sorry about that. We'll tweak that for next time. But thank you, Andrew.
Couple little edits for our slides, but now let's just jump right into this substance. So I'll flip it back to you, Chris.
Yeah, great. So I think it's super important that we reflect on the importance of estate planning from time to time. I will tell you, over the last month, 12 Points has had at least 4 clients pass away. One gentleman that I'd worked with for the last 20 years, he was 101 years old. An amazing individual, really, just a great guy, a veteran, gave back to the country and his community, and was just wonderful in every way. But thankfully he had a really well-drafted estate plan, and there's nothing that's going to be going through probate, and his heirs are going to get the maximum amount of money, and it's all going to go the way he wants. But that's not always the case, right? So you need to plan in advance, and appreciate all of you taking the time to pay attention to this important topic now. So the purpose of estate planning is really for everybody. It's not just the super wealthy, right? You really want to make sure that you have a clear plan to distribute the assets. And let's just rip through the topics that we're going to be covering here, Andrew. I mean, we're going to talk about wills, revocable trusts, otherwise known as living trusts, depending upon what state you're in, powers of attorney, advanced medical directives, HIPAA authorizations, and IREV trusts. I think we might touch on prenuptial agreements for those younger folks on the backside here. But otherwise, that's pretty much the topics we are going to get into, the mass estate tax in a second. So why don't you just kind of get us going on that? This is really important for those mass-oriented folks.
Yeah, this has been long in coming, and I mean, our timing today couldn't be better. I mean, this just came in about a month ago. So, as of about a month ago, and although technically this new law is retroactive to January 1 of 2023. So starting from that date, now going forward, the Massachusetts estate tax exemption, which has been $1 million for essentially forever, has now been increased to $2 million. And it's really what's most important really is that it's now a true exemption. So the way the mass estate tax used to work is if your estate, and just back up a little bit, what do we mean by an estate? What it is when someone dies, it's the value of everything that they own at the time of their death, meaning their home, their retirement account, other investments and savings they may have, the value of a business that they might have an interest in, other real estate, basically anything you own potentially subject to estate tax. And the old law was such that if your estate was over $1 million, you actually paid estate tax, or they would compute the estate tax on every single dollar. So that $1 million was really more of a hurdle or a threshold as opposed to a true exemption. Now it's a true exemption. So if you die with an estate of $3 million, you only pay tax on the amount above the two. It's a true exemption. It used to pay tax on all three. So now if you do proper planning, and we'll get into this a little bit when we talk about trust, a married couple can now shelter up to $4 million from estate tax. It used to be we could actually only shelter, in most cases, really only $1 million. So really, we've gone from $1 million for a married couple. We've really gone from an exemption of $1 million to really $4 million. So, but what that means is that planning is even that much more valuable. Like you can, with proper planning, you can save even more in terms of your estate tax liability. So, some other, there's been the law also addressed some other issues about people who live in Massachusetts and have property in other states, or vice versa, people who maybe say live in Florida but maybe still have a second home or something in Massachusetts. It provides some clarity with respect to how the tax is computed for them. There's still a few outstanding, questions, issues out there, and so we're awaiting some guidance, some clarity from the Department of Revenue. But this is a big change, long in coming, and again, it really increases the importance of proper estate planning.
Yeah, agreed. And Andrew, it's just amazing how long it took for this to come to fruition. And just when you think back before the decoupling of the federal estate tax and the mass estate tax, they were connected at the $1 million level, and now the federal exemption is over $13 million. And that Massachusetts stuck at $1 million, and pretty much so many families today had been confronted, up until recently, with a tax based upon just owning a home. You own a home, you have a couple of other assets, and before you know it, bang, you're over $1 million.
Right. I mean, if you've just sort of been doing the right thing all your life,
right,
but putting money away, in retirement, paying down your mortgage, it just, kind of doing just sort of those basic things, you can find yourself hit with a pretty significant estate tax bill. And this I think will take a lot of people out of that, but certainly, I think there's definitely room for it to go higher. Maybe they're going to kind of do this in installments. Maybe we'll get it up to three at some point. Just quickly, I mean, there are only at this point, I think, about 13, 14 states in the country that even have an estate tax, and at $2 million, Massachusetts has the second lowest exemption. So the only place with a worse estate tax system right now is actually Oregon. So hopefully this is the beginning of some additional tax relief in Massachusetts.
Agreed. Probably an appropriate spot to talk briefly about the federal estate tax as well. So as I said, the current estate tax exemption is in excess of $13 million going up next year. And, under current law, the exemption amount at the federal level. So what does that mean? If we just use a round number of 13 million, means that a married couple can shelter $26 million of assets from federal taxation, which is an unbelievable amount when you consider someplace like Massachusetts, just until recently it was $1 million. But unfortunately, all good things come to an end, and under current law, the estate tax exemption at the federal level is designed to revert back and sunset on December 31st of 2025. So at that point in time, we're supposed to get a cutting and reduction back to the neighborhood of around 6.5 million, give or take, per spouse. So, a married couple at that point would be able to shelter 13. So there's a real potential risk of wealthy families not being able to shelter as much as they would have now in the future. So that's why I refer to this time period between now and the end of 2025 as the golden age of planning. I think there's tons that we can do. So should you know anyone that has significant assets that you're looking to help make smart decisions with their money and their planning, please let them know that that's coming down the pike, and ask them to contemplate being thoughtful and getting in touch with an attorney and qualified financial planner to help them with this. So without further ado, let's get into our primary topic here. So what's a will, Andrew, and why would we need one?
So yeah, I think a will is probably the estate planning document people are most familiar with. Is the classic scenes from movies with the reading of the will, after someone's death. Honestly, that doesn't really happen, but I think it makes for good theater. So will is a legal document. It's provided for or supported by statute in every state. So there are different requirements for what makes a will valid, but basically that it's written, signed, witnessed. Helpful to have it notarized, although it's not technically required. And the person has to be of sound mind and not under undue influence. Nobody is kind of pushing them or forcing them to write it up in a certain way, that they're doing it of their own volition. And basically what a will does really is I would say covers three topics. One, it provides for this disposition of someone's probate assets at their death. And I'm going to come back to that in just a second. Secondly, it's where you name what we used to call the executor, what we now call the personal representative of the estate. So whoever's going to kind of take charge of the estate at your death, make sure that your assets get where they're supposed to go, that final expenses get paid, final tax returns get filed, etc. And then also, if you have minor children, it's where you would name a guardian for them if something happens to you and your spouse before those children reach the age of 18. But just going back to the first point about the disposition of probate assets. So just to be clear on this, I think this is a really important point. A will does not handle the disposition of what we call non-probate assets.
Great point.
Those really fall into three big categories. So one are assets that are jointly owned, which I find 90% of married couples own their home jointly. One spouse dies, that home automatically passes to the survivor. Same if they have any joint investment accounts. Maybe they got a joint bank account. Again, automatically those would go to the surviving joint owner. Even if the will says they're supposed to go somewhere else, it doesn't matter.
Right.
The assets never make it to the will. Also, retirement accounts, those go to the designated beneficiary. It would only pass through the will if there are no beneficiaries. So really important to If you have a retirement account either through work or outside of work, make sure that your beneficiary designations are up to date. And then finally, the other major category of non-probate property is life insurance. Again, where that goes at your death is governed, controlled by the beneficiary designation. So again, make sure for both retirement accounts and life insurance policies that you've got proper, both primary and contingent beneficiaries named.
No, great point. And I would just echo the importance of paying attention to those beneficiary designations from time to time to make sure that they're consistent with your goals and objectives. You might find that, I've seen this in the past where people have been divorced and found out that they still had their ex-spouse named as a beneficiary on their assets, and that just kind of creates a little bit of confusion at the end of the day. So you want to clean all that stuff up. Yeah. So there's simple wills, right? And then pour overs. You want to just talk about why one would want to use one versus the other?
Oh, sure. So, if for someone who has really I'd say sort of a modest amount of assets, don't have young children, so sort of a pretty straightforward situation, then probably a simple will might be all they need, although still worth, talking with your estate planning attorney about kind of the pros and cons. I would say for most people, what they really need is what's called a pour-over will. And what we mean by a pour-over will is that it's used in conjunction with a revocable or living trust, which we're going to get to on the next slide, I think. And so the idea there is that any probate assets get poured over from the will to the trust, and the trust is really where the disposition of assets happens at the time of the person's death. So a pour-over will is it would only be utilized when you have a trust as well. So they kind of go hand in hand. And I would say that's what most people need, but in some situations, a simple will is sufficient where a trust isn't necessary.
Right, and it probably bears a brief discussion here. There are some jurisdictions, some states, New York, for instance. Can't tell you how many times I've spoken to attorneys, trust and state attorneys in New York that tell me, oh, we're just going to use a will. We'll create trusts under the will. We don't need to do a revocable trust or a living trust. Quote, they always end this way. Probate isn't a big deal in New York. And my answer to that is always, okay, well, not a big deal to the tune of $5,000, $50,000, $100,000. What's the question? What's the answer here? Right. So we're staunch advocates in Massachusetts for revocable trusts and living trusts in similar jurisdictions. Majority of jurisdictions are the same. So I would simply say that if somebody tells you that they want to just use a will, we want to really urge them to use revocable trust. So let's get into what a rev trust or a living trust is.
Sure. So living trust, again, a legal document, and it really it can do a lot for you. And as wonderful as I think they are, I think sometimes they're presented as being able to maybe solve even more problems than they really can. So you hear some
good point.
On the radio or I sometimes see things get mailed to me that you get the impression that if everybody had a living trust, that there would be world peace, but all joking aside, they are an important tool, an important aspect of a comprehensive estate plan. So really what they can do for you is I like to think of there being a timeline, and the point with the living trust is it can be helpful from the moment you establish it during your lifetime. Certain things will happen with the trust at the time of your death, and then trust often then continue beyond someone's death well into the future. A trust may run for another generation or two beyond. So there's sort of this a will really only, while you obviously have to put it in place during your lifetime, it only operates at one very specific point in time at the time of your death, whereas a living trust really is utilized starting today from the time you set it up through the time that the trust finally terminates, which could be, a generation or two, beyond your own death, beyond your own lifetime. So it's a much longer time horizon there. So during your lifetime, it can provide for, the management of your assets. If you were to become incapacitated during your lifetime, it also allows assets to, at the time of your death, to pass outside of the probate process, which again, Chris said is mentioned, has both costs involved and, and can take, weeks, if not months, and sometimes even years, unfortunately, to complete. And what it also accomplishes is and I mentioned this earlier, it allows for proper estate tax planning, particularly with the Massachusetts estate tax. What allows it to be done for a married couple is that the first death, to take advantage of that now true $2 million exemption. That the only way for the first spouse to be able to take full advantage of that is to really to utilize the trust at that point and have, if they have enough assets to do this, put up to $2 million in a trust for the benefit of their surviving spouse, and that will shelter it from estate tax both at the first spouse's death and at the second spouse's death, and then the second spouse at their subsequent death will have their own exemption as well. So again, that's why I said that now with proper planning, a married couple can shelter up to $4 million from the Massachusetts estate tax, but it does require the use of a trust, which has to be set up while both spouses are still alive, but that $2 million sort of funding would happen following the first death. So
Andrew, quick question for you there, Andrew, as it relates to, say some people on the call might have existing Massachusetts pour-over wills and rev trust structures that were designed over the last 10 years that were perfect and bulletproof back then. The new change in the Mass estate tax, does that warrant a full review with someone like yourself, or is the funding of those older trusts still going to be consistent and good?
Yeah, well, I'll give you the typical lawyer answers, which is it depends. And I guess it depends on the attorney who drew it up and the way they sort of phrase this. So I can only speak for myself. My documents, sort of, kind of self-adjusted for this, so no need to make a change. But I've reached out and had numerous clients reach out to me with, just to discuss this. So I don't think there's, I don't think there's any harm. I don't think there's any harm in reaching out to the attorney who initially drafted it for you, and it's probably a good excuse to just talk about review other things as well.
Yeah, perfect.
Yeah.
Oh, that's great. I would like to spend another second on revocable trusts, because I have to tell you, this is one of my preferred planning techniques and topics, is to utilize rev trusts to their fullest extent. And by that, I mean, you really need to look when you're creating these trusts downstream. What's the family look like now? What do you think the family might look like in the future? And by that, I mean, are there any special needs that are present? Do you have somebody that has a disability that needs to be taken care of with special care and attention? Are there children that have spendthrift issues? Are there any drug or alcohol issues? Are there any children that are super successful that might not, quote, need the money? Similarly, look upstream, right? So a lot of our wealthier clients come from, imagine this, wealthy parents. So, there's instances where there's money upstairs still with mom and dad. You want to talk to them and make sure that the planning is thoughtful and connected intergenerationally, because if the clients have money and mom and dad have money, we don't want to have mom and dad's assets when they pass come into what's already a taxable estate, or worse yet, a taxable estate in 2026 potentially, when we could do planning with what we call the generation skipping transfer tax exemption, which is way beyond the scope of today, but I'm just going to bring it up and say that, you can talk to your parents with proper planning. they can shelter assets that you can have access to at your level, and then have those assets passed downstream to your kids, their grandkids, and future generations, keeping it out of the estate tax system. That's how you maintain and maximize wealth through the generation. So that's all part and parcel of proper revocable trust, living trust planning, and utilizing what we refer to as long-term trusts, as Andrew talked about before. You know, having something that distributes outright to a child at 25 or 30 to me is not warranted in many instances, because they might be the smartest kids in the world, but things happen. There could be a car accident, there could be a divorce, there could be a business asset that goes bad. You know, people get sued for all manner of reasons, and if assets are in trust, they're better protected than being outright owned. So, stepping down off the soapbox, and we'll,
No, I think that's a really important point that you made, Chris. And you know, if you know, a lot of people are concerned, oh, if I have a long-term trust, my kids aren't going to have access. That's not at all the case. They absolutely have access. We just want to make sure they have access, for the right reasons, at the right time, in the right amounts. And so if you've got a well-drafted document, you've chosen a trustee or trustees that understand where you're coming from, it's not an issue. So but we should maybe we should jump off the soapbox and get to the next slide.
We'll move on here to the wonderful world of powers of attorney.
Yes,
I saw your question here, Tom. I can't see the bottom of that bullet point either on my screen, unfortunately. So I will do my best to come back to you on that. Okay. I see the question though.
I may.
Oh, you do have it. You have it in front of you. Can you just skip back to what that?
Yeah. So it's just the last one is a great way to manage wealth in the event of incapacity, and then potentially reduce estate taxes. So
estate taxes. Thank you. That makes perfect sense.
Yeah.
Thanks. So powers of attorney, really, really critical, right? And let's talk about why one would need one and what one would do.
Yeah, so we're all right. So we've moved on from death and taxes, and now we'll talk about incapacity. But all joking aside, no, really, really important that in the event during your lifetime you become incapacitated for whether it's a week, a month, protracted period of time, for physical and or mental reasons. So it could be an illness, long-term disease, could be things like dementia. You want to make sure that someone has the ability and in a very efficient way to take over your sort of day-to-day financial affairs, whether that be paying bills, filing tax returns, maybe dealing with a business you're involved in, just so that there's a seamless transition in terms of somebody being able to deal with those sort of time-sensitive matters. And the best approach for that is what's called a durable power of attorney. So, so normally a power of attorney, if the principal, that's the person granting someone authority to act on their behalf, if the principal becomes incapacitated, the person they've named, which is called their power of attorney or their agent, their authority ceases. So by statute, every state now has what's called a durable power of attorney, so that even when the principal becomes incapacitated, the agent, the power of attorney, still has the ability to act. So it's really important that you have this document. The alternative is having to go into court, somebody get appointed as a guardian or conservator. That's expensive, takes time, and there's a lot of uncertainty. This is easy, certain, and inexpensive. So it checks all those boxes. Important to have a primary person and at least one or more backup powers of attorney as well.
And I would simply say, as well, as important as a durable power of attorney is, and this, when you sit with your attorney, whether it's Andrew or anyone else that you might retain, the core documents that you're going to get are likely going to be the will that we discussed, the revocable trust, durable power of attorney, the healthcare proxy, and the HIPAA that we'll talk about in a moment. Those are the core documents, and they're all important and needed in their own way. I do want to bring up one point that I see time and time again as it relates to powers of attorney. My experience is that financial institutions and others really, really, really do not like to have somebody come into their office with a power of attorney and say, hi, I'm here to execute on this power of attorney for Fred because Fred's disabled. So as important as they are, you should have them. Just know that there's oftentimes pushback on them. Why? I don't know. I'm just talking real world with you here. How does one deal with that and get around that? Go back to the last slide, that revocable trust that we just discussed. If you were to have a revocable trust and fund it with all of your non-probate asset, those things that Andrew was talking about before that are not your retirement accounts, not your insurance, but your investment accounts, other things like that. Now the trustee, if you become incapacitated, manages the trust for you, your successor trustee. For whatever reason, I have found that a successor trustee can waltz into any financial institution and get pretty much anything done. They roll out the red carpet. But if you're there with a durable power, they don't like them, particularly in New York, I've found. So I would just be cautious of that and urge everyone, to the extent that you have a revocable trust, consider what we call funding it, meaning take assets that you can, put it in there. The revocable trust is your alter ego. There's no gift, there's nothing else. It's you until you can't use it, until you can't make decisions, and then the trustee takes over. So again, super important, just tips of real world there. So I'm sure you've seen things like that as well, Andrew, right? I'm not speaking out of school.
I've let's just say I've had many a conversation with counsel to various banks in this area, trying to.
Yeah. So now let's get into the world of healthcare proxies.
Yeah. So similar context, a period of incapacity, but if it rises to the level where you need medical care and you're unable to express your wishes yourself with respect to that care, either care you want or care you don't want, it's so important to have a healthcare proxy in place where you've named a healthcare agent who is essentially your voice, who is going to make sure that your wishes regarding your medical care are carried out. How do you express those wishes? I would say two ways. You can put them in writing through something called, or referred to often as, a living will or advanced medical directive. I've heard some other terms as well. It's just a way of putting in black and white what your wishes are, and let's just be honest right here. I mean, we're talking about sort of primarily kind of end of life decision making, and what you would want, what you wouldn't want. So if you can put that in black and white, great. I personally think, while I think that's important, I think it's also really important to have conversations with the people you're gonna put in this position, whether it be a spouse, children, maybe it's if you don't have either of those, maybe a different relative or friend, but whoever you're going to be naming as your primary and backup healthcare agents, they really need to know how you feel about this stuff. And that's not just a one-time conversation, because I think our feelings about that may change over time. So just make sure that you're letting those people know how you feel about this, because again, their job is to carry out your wishes, not to apply their own feelings on the subject, not to just try to kind of figure it out. You really need to let them know what you would want and what you wouldn't want. So and then the other document, I think maybe it's the next slide, Chris, is would also have what's called a HIPAA release. So some regulations came out, I don't know, maybe it's 15, maybe even going on 20 years at this point, about privacy, regarding somebody's personal medical information. So if the point is, if you're going to give somebody a healthcare proxy, name someone as your healthcare agent, you want to make sure that they're going to have access to your personal medical information so they can, obviously make an informed decision on your behalf. And that's what this HIPAA release does, is it tells doctors, nurses, et cetera, that they have permission to share your personal medical information with somebody serving as your healthcare agent in your healthcare proxy. So really important to have that. Make sure that your estate plan includes either a separate HIPAA release or the HIPAA release language within the healthcare proxy document. I do them separately, but I've seen other attorneys who combine them.
Excellent, excellent. So one other point that I absolutely want to make before we continue here is those core documents that we just covered are super important for all of you on this Zoom, this webinar here. They're important for your friends, your family members. But one area that gets overlooked is 18-year-old young adults. So
Great.
when you have a child that has just turned 18 years old, you are no longer authorized to make those decisions for them in Massachusetts as it relates to healthcare or financial decisions, et cetera. So sadly, if the child went off to college and became ill or something happened to them, absent planning, you wouldn't be able to make those decisions without going to court and getting court authorization and approval. So many times we make it a practice here at 12 Points to speak with our clients that have children that are turning 18. Just Tuesday this week, I signed, I notarized a power of attorney, healthcare, and HIPAA for an 18-year-old son of a client of ours, and super important, right? You got to pay attention to that. Nobody ever wants to have to use those documents, but boy, if you needed them, thankfully you'd have them. So
yeah, when you're sending the kids off to college, it's not just about the extra long sheets and the posters that put up on the dorm room wall, but really important that they have a healthcare proxy, HIPAA release, and durable power of attorney.
Absolutely.
For reasons.
So we're going to finish off here quickly. We want to be respectful of all your time. I've been doing the best I can to answer the questions that were rolling through in the chat. I'll touch on some of those in a moment should we have time, but irrevocable trusts, right? This is an area that's near and dear to my heart, as you know, Andrew. Why don't you kind of talk us through why one would want to use an irrev trust?
Yeah, so it's really the idea here, I would say primarily is, sort of a higher level of estate tax planning. So I think people who have, a little bit more significant estates, maybe people where the federal estate tax is, may very well, be an issue for them. The idea here is to remove assets from your estate, especially like before they grow in value, even more. So you have assets today that are worth X. By the time you die, maybe they're going to be worth, say 5X or 10X, 10 times their current value. By creating an irrevocable trust, moving the assets in those today, we are removing them from the estate at today's value, as opposed to if you don't do that, they're going to be in the estate at that, sort of much higher appreciated value. And what's great is that what we've been using, well, so two things. So one, it's a great tool for life insurance policies, because owning a life insurance, being named as the owner of a life insurance policy really, for all intents and purposes, really doesn't matter. What matters is that you have the coverage and that your family members are beneficiaries. And so a particular form of irrevocable trust, irrevocable life insurance trust, often referred to by the acronym ILIT, is a great tool. We use them all the time to get those life insurance policies out of your estate for estate tax purposes. Because while life insurance proceeds are not taxable to the recipient, life insurance policies, the full death benefit, not just the cash value or something like that, but the full death benefit is part of somebody's estate unless it's owned in an irrevocable trust. So life insurance, you've got life insurance policies, talk to your attorney about perhaps creating an islet or islets for those. And then the other main type of irrevocable trust we use is something called a SLAT, and there's a mention there on the slide, a spousal lifetime access trust. And this is kind of a have your cake and eat it too type of arrangement whereby one spouse puts assets into an irrevocable trust, naming, perhaps children and grandchildren as the primary beneficiaries, but we can include the other spouse, hence the S in the acronym there. We can include the other spouse as a permissible beneficiary, sort of just in case of emergency. Let's say the couple's financial situation drastically, declines and they need some of those assets back. We can get them out, to the spouse who did not put the assets in there. So it's kind of a way of doing estate tax planning, but also having, retaining some additional peace of mind. The other place we sometimes use irrevocable trust is it can help in a situation where somebody is trying to qualify for Medicaid, which in Massachusetts is known as Mass Health. So if you're trying to get the state to pay for long-term care and protect assets at the same time, an irrevocable trust can be helpful. Because it's so hard to qualify, because the amount of assets some of you can retain is so small, we don't tend to see too much of that, but I just wanted to point out it is sometimes a tool used.
It's definitely a topic of discussion from time to time.
Yeah, we could talk for probably a full day about that topic, and it's
and we could on irrev trusts. I will simply just round that out by saying that irrevocable trusts are one of the probably the second most important tool in my toolbox as it relates to the planning that I do. Being able to move assets outside of the estate, take advantage of valuation discounts, especially for business owners and others with assets that are appreciating, as you said, really, really important. And this is the sort of planning that I was referring to at the beginning when I said the golden age of planning. This is where, for those wealthy individuals to really be looking at moving assets into trust so that you can use that full exemption that you have available to you today, 26 million per family, a married couple, I should say, and be able to make sure that you're not going to get whipsawed in 2026. So there's a lot to be done. This is one of the most important tools in that toolbox. And we're going to just touch on the last topic, which is what do you do before you get married if you've got money? And that is prenup. So let's talk about that, and then we'll get done here. Andrew, how's that sound?
Yeah, no, that's great. We can wrap up on this topic. So prenuptial agreement, obviously not, sort of has a reputation for, not being the most sort of, kind of romantic thing right before, you enter into marital bliss. But, the way I think about it is, you wouldn't go into any sort of, business arrangement, partnership with somebody without, sort of having something that said, what happens, when the partnership, ends. And so that's really the idea here, is to say, we're about to get married. We're obviously anticipating to, till death do us part. But if things don't work out for any reason, let's just go ahead and decide now, when we're clear-headed, when we're not arguing about things. Let's just go ahead and decide up front how things will play out. Let's do that work now, so that we're not having to do it in a time of where we're emotionally compromised and we're having to pay attorneys sort of obscene amounts to work it out. Let's just make the deal ahead of time. But a proper prenuptial agreement should also address what happens, if one of the parties dies, while they're still married. And the idea there is that we just want to make sure that each party can decide totally on their own, not constricted, not limited by state statute, because every state has rules that talk about how much a spouse has to leave to their other one in their will, like sort of a minimum amount. And we'd rather not be subject to statutory rules. We want each party to decide on their own what they want to do for each other in the event of their death. So while the focus of a prenuptial agreement tends to be on what happens in the event of divorce, it actually is tied into, kind of estate planning in terms of what happens at death as well. So I think those are probably the main two things that a prenuptial agreement should address. And again, it's not, don't buy into that kind of negative, preconception about it. I think it's an important discussion for people to have. I tend to see it more in maybe sort of second marriages or things like that, but not always.
No, that's a really good point.
I think I don't want to say everybody, but I think most people should at least talk to an attorney about it, ahead of a marriage. And it's important to do it at least a few months in advance.
Yep.
Prenuptial agreement, they get signed, the night before the wedding. Good chance
they're useless.
It's not gonna hold up. So
no. So we're just gonna blow through, get right to the end here. So first off, this is where you can find me, Chris at 12pointswealth.com, or actually it's now Chris at 12points.com. So you can email me there. You can call 978-318-9504 if you have any questions. But more importantly, if you're looking for a conversation with Andrew Butler, you can find him here at andrew@archstonelaw.com. And the phone number is 781-314-0113. Andrew, is always a pleasure, my friend. Thank you for your time today, and appreciate all of you being so diligent and attentive. And certainly all the questions were great. I did my best to answer all of them as they came through. So I wish you all a happy and healthy Thanksgiving, and look forward to catching up with you all soon. Be well, everybody.